Hello, my name is Gregory Brown, and I'm a business and trial lawyer with the law firm of Brown Charbonneau. At our firm, it's our goal to help educate our clients about the litigation process. This helps them prepare for each phase of the case, as well as arm them with valuable information to help them make better informed decisions. One such area is the client's deposition, or sworn testimony under oath. So the deposition, it's part of the discovery process that the parties conduct before trial to learn about the facts and claims of the other side. A deposition typically takes place in a conference room, law firm conference room, and consists of a witness, you, being asked questions under oath by the other lawyers on the other side. All of the questions and answers of a deposition are transcribed by a court reporter, and the transcript becomes part of the discovery of the case that can be used at the time of trial. Your lawyer will attend the deposition with you for purposes of protecting you from unfair, misleading, unclear, or other improper questions. Your lawyer may object to the questions. Your lawyer may also ask you questions at the end if there's a need to correct, expand upon, or clarify some of the answers you gave. Now, next, it's important that you take the time to prepare for your deposition, both your attorney and on your own. Since most cases settle before trial, this may be your only chance to tell your side of the story. How well you do in a deposition often has a significant impact on the case, including the settlement value of the case up or down. So it's important to do well. Remember that your testimony in deposition is binding and under oath. Now, while the deposition will be held in an informal setting, your attire and appearance should still be considered to be dressed conservatively or business casual, or if you were going to court. Again, you're trying to make the best impression possible. Now, this is particularly important when the deposition is being videotaped, as it may be shown to the court or the jury at trial. Since the lawyer is evaluating your credibility and likability, try to make a favorable impression. Don't get angry or defensive. It's okay to get genuinely emotional during the testimony, but ultimately one of the goals is for the attorney to leave the deposition understanding what a nice, likable, and credible person you are. So next issue is to take time and think before you speak. Listen to the question and understand before you answer. Sometimes lawyers ask questions that don't make sense. Before you can answer a question truthfully, you must understand it. Don't be shy about asking the lawyer to repeat the question or rephrase the question. Next, if possible, try and answer all your questions with yes, no, I don't recall, I don't know, or I don't understand your question. It's what I call Greg's Rule of 5. Do not volunteer answers or information. Answer only the question asked. Do not try and explain your answers unless you and your attorney decide that in a particular instance you should. This also includes documents. Don't identify documents unless specifically asked. Next, one thing you don't want to do is guess. Sometimes telling the truth and being accurate means saying, I don't know, or I don't remember. Often witnesses feel that they should know the answer or remember the answer, so under the stress of the moment, they kind of make up the answer. Don't do that. If you don't know or don't remember, say so. If you are asked about dates, times, or other specific questions, don't guess. Now, you can approximate if you know some ranges, but always make it clear that you're approximating. Next, documents are usually used in depositions, such as photographs, business records, contracts, pay stubs, tax returns, etc. If you're asked about a document, take time to look at it and read it before you start answering questions. If the document isn't provided to you, ask to see the document. Or if they don't provide it to you, it's okay to say something like, well, without looking at the document, I would say X, but I need to see the document to be 100% sure. Next, don't let the examiner put words in your mouth or summarize your testimony. Attorneys may try to alter the answer ever so slightly when summarizing a prior answer as part of another question. Be careful. Your attorney, of course, will be watching for this as well. Next, be careful about giving absolute answers unless you're really sure. The adverse attorneys may try and catch you in a contradiction.